Welcome everyone to today's webinar, the EU Data Protection Reform and what you can do to prepare. I'd like to introduce to you our guest speakers today, Dan Revel, partner at Travis Smith Lawyers, and Chris Payne, Senior Technical Consultant at Infinigate UK. Dan joined Travis Smith in 2001 and became a partner in 2007. He leads the firm's intellectual property and technology practice and has significant experience in the exploitation and protection of all types of IP, in particular matters relating to databases, software and the internet. He regularly leads substantial projects relating to technology implementation, outsourcing and software development, often in the financial services, leisure and retail sectors. In addition, Dan regularly advises clients on data protection and confidentiality issues. Dan is recommended as a leading individual in both the Legal 500 and Chambers directories, in which he has been described as tactically astute and a tough negotiator. Our second guest speaker is Chris Payne, and he's been working at Infinigate UK for over 3 years, becoming Senior Technical Consultant in 2014. After previous roles as a voice engineer and as a systems administrator, Chris joined the team with a very broad IT skill set and an understanding of daily challenges IT teams are faced with. In his time at Infinigate, he has worked with more than 11 vendors providing post-sales, pre-sales and training engagements, using his experience to deliver solutions for Infinigate's partners and clients. Some of Chris's projects include working with national police forces, transportation operators, central government authorities, ombudsman organisations and FTSE 100 retailers. Some key topics that we will be covering today include summary of the new regulation and how this is different to what we have in place today, how organisations should react to a breach and penalties for non-compliance, likely oversights as a result of the changing regulation, how the role of the IT manager has changed in recent times, and how organisations should begin to tackle something as complex as a DLP project. We will also have time towards the end of the webinar for a Q&A. However, if you have a question beforehand, please feel free to submit it via the Q&A panel shown on the right side of your screen. First, I'd like to start off with a poll to get a better idea of where the audience sits in terms of their understanding of the key changes of the reform. So I'll just launch that now. Can I please ask the audience to respond to the poll on the screen, indicating your understanding of the reform and the impact on your organisation? Just wait 10 more seconds. Okay, great. Chris, do you want to provide some commentary around the results?
Sure. So it looks like what we've come back with here is a very, very large majority under the little understanding category. And I don't think this really comes as a surprise to us. Hopefully a lot of the listeners today can take away some of the key points from today's webinar, and kind of the purpose of today's webinar is for that particular result. But this is a discussion that I have with a lot of my customers. In the UK, we're very familiar with Data Protection Act. In fact, it's taught a lot in schools. But the changes to the new legislation are, we kind of assume that they're the same thing, or they cover the same areas, they're just European-wide, but that's not necessarily the case. So again, just to reiterate, I hope people can take away a lot from today's webinar.
Thanks very much, Chris. Well, Dan, I was just wondering, could you please summarise what this regulation is all about?
Yes, certainly. Thank you, Lulu, and good morning to everybody. I think it's possibly worth just putting into context, first of all, what data protection compliance and legislation is all about, and why we have it at all. And we all tend to think of data protection in terms of the regulation and control of organisations. It's what we look at as part of our jobs. But of course, data protection actually exists to protect fundamental human rights to privacy, and it actually came out of the Human Rights Convention. And the first attempt to create a law in the UK that dealt with data protection was in 1984. I'm sure George Orwell would have been impressed with the timing. But the problem with that law was that it didn't really address computerization, which, given it was the mid-80s, was a bit of a ridiculous oversight. And there was no harmonization across Europe for data protection either. So the European Commission then introduced a new directive in the mid-90s, and that was implemented in the UK by way of the Data Protection Act 1998, and that's the law that we all know and that we're all subject to today. And I think it's fair to say that around about that time, in the run-up to the new Act coming into force, that there was a huge level of interest around industry in the UK. And I would almost say a paranoia about the way that organisations were going to struggle to try and comply with this new onerous codified law. That level of interest started to tail off after a few years, and that was largely because organisations started to realise that if you didn't comply with the Data Protection Act 1998, it tended not to really matter. No one seemed to get pulled up by the regulator, by the ICO, and even if they did, typically the worst that would happen was a slap on the wrist. The level of interest in data protection compliance then started to climb again towards 2010, when the UK introduced some rather more stringent laws, and the ICO had greater powers to levy bigger fines. And then just generally in society, an awful lot's been going on that has related in some respect or another to data protection. So things like digitization of data, big data, the proliferation of social media, direct marketing, mobile computing, the Internet of Things, the right to be forgotten. All of these things have sort of captured the public's imagination, and the press in particular have really latched onto the whole issue of course, of media intrusion and the Leveson inquiry. And all of these things actually relate in some respects to another to data protection, which is why we found ourselves in January 2012 being presented with a brand new draft regulation from the European Commission. So it's now 3 years old, this regulation that we're going to be talking about today. So where is it? What's actually happened to it? Well, anyone who knows anything about European law will know that introducing European-wide laws is typically fraught with a number of problems. And traditionally, there are 3 European institutions which all weighed in and like to argue and put forward their case, and that's the Commission, the Parliament, and the Council. And that's what's happening here. We've got these 3 bodies all debating the finer points of this new regulation, which is an incredibly ambitious plan for the overhaul of data protection regulation right across Europe. Italy currently holds the presidency of the European Council, and it has said that it will make data protection a priority. However, it's now the 3rd consecutive presidency state to say the same thing. But what the plan is at the moment is that in May this year, the new regulation will be adopted, and that will probably mean that it comes into force in the UK about 2 years later, so sometime in the summer of May 2017. Having said that, I think there's already some recent slippage, and I read a blog just on Friday suggesting that it's more likely to be early 2018 when the regulation comes into force. But either way, we've got a couple of years at least to prepare for the new regulation, but also to find out what's actually going to be in it.
Okay, excellent. Also, could you highlight how this is different to what we have in place today?
Well, absolutely. There really is a big change, as I've said, and there's probably enough changes to sort of fill a day's worth of a talk like this. But what I'll do is I'll just pick 5 key proposed changes, all of which I would think would be of interest to any organisation. And the first one is the changes to what we mean by personal data. And anybody who is involved in data protection compliance will know that the meaning of personal data is right at the heart of data protection compliance. It basically encapsulates the whole notion of privacy and personal data and the ability to identify an individual, usually by reference to their name and then other bits and pieces of information that are added to that. And the precise meaning of that in the UK at least has been sort of gradually narrows so that data protection applies to less and less information over time. That is absolutely going to change and will be broadened. And what the new regulation focuses on in particular is what it calls indirect identifiers, and in particular online identifiers such as cookies, IP addresses, geolocation data, that sort of thing. The sort of information that you can sort of aggregate and put together and triangulate it to create a picture of an individual, even if not necessarily by reference to their name. So I think it's fair to say that the sheer amount of information relating to people that is covered by data protection laws will increase enormously. The second thing to mention from regulation is the justifications for processing that any organisation has to have before it starts holding or using any personal data. There are various justifications under the present rules, and the most common one, the one we're all most familiar with, is consent. If you've got someone's consent to process their data, then you are, of course, allowed to process it. And then there's lots of other exemptions and justifications that are specific to sectors like journalism and health and so on. But if none of those apply and you haven't got consent, what we quite often do is we use the fallback justification, which is the legitimate interests justification, which effectively works so that if we believe that we have a legitimate interest to process data, then we can do so, provided that we're not overriding the sort of freedoms and privacy of the individuals in question. And that, as I say, that justification is used quite widely by organisations. That the ability to use that is going to be narrowed significantly by the new regulation, and will bring the whole of Europe into line with the position in Germany now. And in fact, if you're a public body, you will not be able to use the legitimate interest justification at all. And I think the result of this is going to be that the reliance on obtaining consent for processing is going to become far greater. And on top of that, what the regulation will do is actually make obtaining consent much more difficult or much more highly regulated, if you like. And what the regulation says is that all consent must be freely given, informed, specific, and explicit. And so as a general rule, what the regulation is probably going to do is to say that you can't get implied consent. That will never be good enough. You will always have to get very clear, explicit consent. And there is also the possibility with consent under the regulation that every bit of consent you receive will have an expiry or have a time limit upon it. And once you get beyond that time limit, you'll have to go back and renew the consent, if you like. The third topic to mention from regulation is the obligation of organisations to appoint data protection officers. And this is undoubtedly one of the most hotly debated topics in the regulation, and it's far from agreed. But what will definitely happen is that every organisation which meets a certain criteria will have to appoint an individual internally who will act as a data protection officer and will monitor compliance and so on. The real sticking point at the moment is what the threshold is when you look at an organisation for deciding whether or not you need to have one of these officers. The European Commission is saying that the threshold is every organisation with at least 250 employees, whilst the European Parliament is saying that it's any organisation which processes the data of 5,000 people or more in any 12-month period. So taking that view, it could actually be quite a small organisation with a sizable database. Either way, every organisation, every company, across Europe will need its own data protection officer if it meets whichever criteria is the relevant one once it's been agreed. And you will have to lodge details of your data protection officer with the local regulatory authority, so the ICO in the UK. So what does the data protection officer do? Well, their task is to make sure that the company it's employed by is aware of its data protection obligations. The individual will monitor compliance and will implement policies and will sort of act as a bit of a trade union shop steward, if you like, in that they will be acting independently of the company, but of course reporting into and being paid by the management of the organisation. They will also monitor the handling of data breaches, and they will be the contact point for the data protection authorities. The fourth point to mention under the regulation is the obligation on organisations to carry out what are called impact assessments. Now, there's a lot of new governance requirements in the regulation, but one of the potentially most onerous is this obligation to do impact assessments. And we really are entering the realms of European red tape here, I'm afraid. So what is an impact assessment? Well, it's an exercise where an organisation has to identify, understand and address any privacy issues before it starts processing any personal data. So before you start doing anything, this data that you've got hold of, you've got to sit down and have a think about what the risks are, the data protection risks are. Now, this isn't something necessarily new, and if you look at the ICO's best practice guidance, you'll see that there are lots of information and sort of helpful toolkits and so on for doing these informal impact assessments, but they're going to become mandatory. It's not clear when, at the moment, when you'll have to do these assessments and when you won't have to do them. The Commission is saying you'll always have to carry out an assessment before you start processing data, which just seems completely unworkable. But it's likely there'll be some sort of materiality threshold where there's a real risk of any sort of prejudice to the privacy of individuals, where it's particularly sensitive data, if it's children's data, if it's large-scale video surveillance, that sort of thing, then I think an assessment will have to be carried out. And when you carry out these assessments, you then have to document your findings, your thought process and your findings, and pull together a sort of internal report. So it's going to be a lot of work for someone to do, and doubtless the data protection officer, if you've got one, will be fully plugged into that. There's a possibility that if, having carried out your assessment, you think there is a high risk to the sort of privacy and protections of individuals, then you'll have to report to the local authorities, the ICO in the UK, and tell them about what you're doing and obtain clearance in advance. It's not yet been agreed that will be part of the regulation, but it might well be, and that again will really impose a huge burden on organisations and will have a significant timing impact as well. The final point to mention, which I've lifted out of the new regulation, is around notifying data security breaches. Now, currently, under the Data Protection Act 1998, there is no need to tell anybody if you suffer a data security breach, unless you happen to be operating in certain sectors, your ISP or you're a bank, for example. And in some countries there is an obligation at the moment, so Germany is probably the best example of that. But other than that, there's no obligation to tell anyone. Now, the regulation is going to change all that, and it's going to require breaches to be notified to both the regulator, so the ICO, but also to all of the data subjects whose details have been compromised. There is a debate as to whether or not every single data security breach will need to be notified. The European Commission thinks that it should be. Again, it seems rather unnecessary. But I think what will probably happen is there'll be a materiality threshold. So if there is a bit of a risk associated with that data security breach, you will probably need to decide that a notification is needed. The real difficulty is going to be around the timings that are imposed on organisations. The Commission originally said you've got 24 hours from discovering the breach to tell the ICO and tell the data subjects what's happened. That is probably going to get pushed back to 72 hours, but even that is not very long. You know, you suffer a hacking or whatever, or you lose your laptop on a Friday night, and you've only got till Monday night to work out exactly what you're going to tell the ICO and what you're going to tell all these thousands of individuals about losing the data. So I think it's very important that organisations will have crisis policies put in place, and they will rehearse them, and they will know exactly how to react when a data security breach occurs. And it's worth mentioning that this obligation to notify will apply not only to data controllers who own the data, but also to all of their processors who are appointed as sort of outsourced service providers. At the moment, as you may know, a data processor isn't obliged to comply with the Data Protection Act. All the obligations sit with the customer, sit with the data controller. But there's quite a lot in the new regulation that actually covers processes, and then the obligation to notify security breaches is one of them. So that's just 5 key topics that are in the regulation that will see the light of day in one form or another. But there is, as I mentioned on the slide there, there's plenty else besides that you'll have heard about. The right to be forgotten, it's been in the press a lot recently, data portability, and the territorial reach of the regulation, and the fact that it might well impose obligations on overseas companies. But just for now, that's 5 of the key points.
Great, thanks very much, Dan. Could you please suggest how an organisation should react to a breach?
Yeah, certainly. I mean, most of the answer to this is really procedural and operational, and probably one more for Chris than for me. But just a few pointers from the lawyer's perspective. The first one is just to say that you really do need to take it seriously if you suffer a data security breach. Sounds like a pretty obvious thing to say, but it can be extremely costly to your organization's reputation, particularly if you're consumer-facing in any way. You can suffer a pretty hefty penalty from the ICO. The regulator, your sector-specific regulator, can sometimes issue fines of their own. So the FCA, for example, can do that. There's huge costs of investigating and rectifying security breaches. And there's also a possibility under the Data Protection Act that if you lose control of an individual's data, that they can sue you. They can bring a civil claim if they feel they've suffered a loss. That's not something we've seen a lot of, but there is always that risk out there of a class action. I think the first thing to do is look at what you can actually do to start addressing the risks that you face. Or to put it another way, what should you be doing before a breach, a data security breach, actually occurs? And it's worth bearing in mind that the 7th data protection principle, which applies to all organizations, the very basic obligation to implement appropriate security measures to protect the data that you hold. So what do you need to consider? Well, I think the first thing to consider is what personal data does your organization actually hold? Do you need all of that data on your databases? Can you purge it? There is a general obligation on every organization not to hold data for longer than is necessary. So you should be getting rid of stuff anyway, and the less you've got, the less risks you face if there is a security breach. And then just have a look at what the likely risks are that you face, and these will be both physical and technical. So look at things like the break-in of premises, as well as the likelihood of loss of data in transit over communications networks, and hacking and weak passwords and all those other sort of technical points. And worth also bearing in mind that the ICO has issued some very helpful guidance in May 2014 around assessment of risks from an organization's perspective. And don't forget that a lot of third parties probably hold your data on your behalf. I mentioned data processors before, but there'll be data centers that you use. Your staff might use cloud storage facilities like Dropbox or Google Docs. Are you on top of all of that, and are they fully appraised as to what the security issues are around that? And then I've mentioned on the slide there, do you actually appear to be on top of data protection compliance? If there is a problem and you find yourself in the firing line and under investigation from the regulators, then it would certainly be helpful if you, in fact it is hugely helpful if you can show that you were aware of data protection compliance and you'd taken the measures necessary and you'd undertaken training internally and so on and so forth. And then, have you actually got a team in place to react when there is a data security breach? Not just an internal team, but do you know who to speak to at the insurers? Have you got PR people lined up? Have you got lawyers ready? Have you got forensic IT consultants and security experts? Have you got all these people? You can press a button and they're all primed and ready to go. The last thing you want to do is be trying to instruct all these people or scrabble around for contact details when you've had a major security breach. So what happens if there is actually an incident? Well, again, just from the sort of lawyer's perspective, a couple of pointers. Do I need to tell anyone? Well, as I've mentioned, you don't legally need to tell anyone, but the ICO has issued some helpful guidance, and you could take the view that you err on the side of caution and you tell the ICO, you tell data subjects about every breach. I don't think that's a sensible approach at all. You need to evaluate the risks of identity theft or the damaging disclosure of any sort of health or sensitive data. And what can you do with your data subjects? Can you offer them any identity theft insurances as to try and placate them, that sort of thing? And do you need to speak to any other regulators like the FSA? It might be you want to speak to the police as well, and if there's any theft or blackmail with the loss of the data, then it might be worth doing, although typically not really worth holding your breath for much of a response from them. And finally, just be consistent in your approach and make sure that your one senior person in the organisation is dealing with all the different regulators and all the external parties. So there's a consistent voice. Be as truthful as possible about what's happened, but also try and paint your organisation in as positive a light as possible.
Yeah, thanks very much, Dan. What kinds of penalties will be imposed on organisations for non-compliance?
Well, this is probably the one bit of the regulation which will make any senior stakeholder in an organisation sit up and take some notice, and it's definitely going to be the case that taking a view on data protection compliance could very rapidly become prohibitively expensive. At the moment, as I mentioned, the maximum fine in the UK is £500,000, and we've not seen any, or very few fines that have been levied that are of that size. And the key tool that the regulators have at the moment is public censure, and the ICO will publish full details about data security breaches that it's investigated, and they will make the information available to the press, which is why we find out about all these stories. But it's a relatively toothless regime compared to anti-competition rules or anti-bribery financial services and so on. So what the new regulation is going to do, and this is yet to be agreed, but the latest proposals are that the maximum fine for breaching the regulation will be the greater of 100 million euros or 5% of global annual turnover. So the sort of fines that we've seen for anti-competitive behaviour in Europe and the likes of Microsoft have been hammered for hundreds of millions of dollars. That will be available to the regulators now right across Europe. Now, in reality, I don't think most breaches are going to attract fines of hundreds of billions of dollars. But having said that, I think there'll be a change in the mindset of the regulators, and it's likely that they feel that they are in a much greater position to bare their teeth when investigating breaches.
Yeah, okay. Fantastic. Are you able to give some examples of some security breaches?
Yeah, just a couple of, yeah, sorry. A couple of quick ones from me. I mean, a lot of the biggest, most high-profile examples have been in the public sector, and I think Chris will touch on that shortly. A couple of examples here quite interesting. The first one is the British Pregnancy Advisory Service, whose website content management system was hacked because of some pretty poor vulnerabilities in its and poor coding practices, which made it really easy to hack. And an individual accessed the details of 9,000 people who had contacted the BPAS via its website requesting callbacks because they wanted to discuss particular pregnancy-related issues. And this individual got a hold of the details of those 9,000 people and threatened to publish them. Effectively, it was a blackmailing. And it was a really sensitive issue because those individuals, the ethnicity and religion of a lot of those individuals was such that had it been known publicly that they were requesting information around pregnancy-related issues, would have put them at really serious personal risk. So the police got involved and actually put a stop to what this guy was doing. But the ICO investigated, and they found there'd been a serious contravention by the BPAS of the Data Protection Act, and they levied a fine of £200,000. Although interestingly, that was reduced to £160,000 if the BPAS paid quickly, so rather like a parking fine that you pay your local authority. And then the other example, which is much more recent, I mean this is very, very recent, just in the last couple of weeks, Moonpig, the personalised greetings cards website, has a smartphone app, and they have 3 million or so registered users. And they were contacted 18 months ago by a software programmer who had been using the app, and he discovered that it's very, very easy to change your login details so that you can actually adopt the login persona of someone else, one of these other 3 billion people, and you can do this as many times as you want, and you can access all the personal details of these different people. You can see the name, address, email address, phone number, birthday, possible digits of the credit card expiry details, their friend's birthday, all those sorts of things. So really ripe for identity theft. So he told Moonpig, and they said, thank you very much, we will sort this out. But they never did sort it out, even though he kept reminding them of this problem. He got so fed up with it that a few weeks ago, after 18 months, he went public and told the press about what was going on. And the press have shown great interest in this, as you might imagine. Also, the ICO has shown great interest and has actually tweeted in the last couple of weeks that they are investigating this. I suspect the fact that that not only has there been a breach here and sort of failings on Moonpig's part, but the fact they didn't do anything, having been told about it, suggests that this really could be a huge problem for Moonpig, both from a fine perspective but also reputationally.
Yeah, okay, that's great, Dan. Chris, are you able to provide some examples of data breach?
Yeah, absolutely. I kind of wish I went first now. Dan is obviously a very impressively knowledgeable man, so I'll try my best. This is an interesting question to have, really, because as Dan has kind of already alluded to, we see a lot more kind of public disclosure of these types of things happening now, and it's really indicative of the time when you kind of talk to someone outside of your work, and they say, where do you work? I work in IT security, and they say, oh, did you hear about the Sony hack? What do you think? And for me, it's a huge change in the public just to kind of understand what I do, I guess, and ask me questions about it. But I got a case study that I kind of pulled off of the ICO's website, and go have a look at the ICO's website. It's great for people like me trying to find these types of case studies, but they've also got some really cool stuff on there around statistics of data breaches and how it happens to have taken place. But the one I particularly want to highlight to you is the Ministry of Justice, and the reason why is not because it's the most recent, but because it has a fairly interesting timeline. It starts from some time back. So in 2011, they actually lose a laptop hard drive, and this hard drive contains 16,000 pieces of information about prisoners. Now, it's not just who the prisoner is, which prison they happen to be in. We're also talking about known aliases, accomplices, the crimes, the victims. So it's some pretty severe stuff, particularly if there are any pending trials happening at that time, which rely on that time. So very serious. They, of course, do inform the ICO, so they've made the right choice at that particular point in time. The ICO investigates, actually finds that they haven't been using any form of encryption on their data at rest, and so their recommendation, without any kind of penalty, is you should now have encrypted hard drives as a result. So, of course, they do actually take that advice on board. They do deploy encrypted hard drives to all of their sites across the UK. And unfortunately, the inevitable takes place, which is in 2013. They happen to lose not a laptop this time, but a backup hard drive. And this contains a lesser number of details on it, but the IT is not impressed, because what actually turns out to have happened is that although they've deployed hard drives with the capability of encryption, they haven't actually enabled the software to complete the entire solution. So it was unencrypted data. And what that actually resulted in was some pretty mean comments, I must admit, from the ICO about the competency of their IT department, but also a fine of £180,000, which is for the public purse, and for in these times where we see a lot of budgetary constraints, is obviously a significant amount of money.
Okay, fantastic, Chris. Thanks very much. How can organisations start their journey to compliance and tackle something complex as a DLP project?
Okay, so this is again another really interesting question for me, because any of you that have worked with me in the past, we as a department provide post and pre-sales engagements for all of the vendors that we work with, and we go in and we install and work on these solutions, but we get to talk to IT departments. We get to spend days with them. We get to talk about other projects that are taking place, and of course DLP is something that does come up. And there are, there are kind of two customers that we tend to see out there when it comes to DLP. The third is obviously the one that we're not talking about today, which is the one that implements a DLP solution. But the two that don't generally are customers that are relatively small and haven't, well, I guess have yet to think about some kind of solution. So they'll say to us, we haven't thought about it, or it hasn't happened to us yet, so there's no need for us to think about it. We tend to see those as a kind of a head-in-the-sand type approach. The second type of customer that we commonly come across are those that have tried to implement some kind of DLP solution, but maybe have had some kind of issue in doing so, maybe haven't communicated properly to the business that that's what they intend to do, and therefore they've had to can the project at some point, maybe due to complexities or I guess rubbing some people up the wrong way. So we tend to see those two types of customers. Now, in terms of how we kind of approach those two types of customers, of course, Dan tends to have the best answers for those with the head in the sand. And I've got some statistics here on the screen just to highlight that for you. So 93% of large organizations have suffered a security breach. That's actually coming from a central government organization there. That's a very significant number there. And we've also got at the bottom 60% of employees exchange data with 10 or more people daily. So this isn't really a problem that you can ignore. Your data is on the move, and you need to know what that is. You need to inspect that leaving your premises. You need to see what that is. So these two statistics here kind of sum that up for me for the head-in-the-sand type user. In terms of the user that has kind of had the aborted takeoff, I actually had I went to see a local authority a couple of years back, and I must stress I wasn't working on their DLP project at the time, but they had one running, and the team's quite small, so I was kind of in there and gauging the response. And they'd actually implemented a new system whereby they were going to inspect emails, inbound and outbound, to their organization, and they were going to reject any emails that happened to contain a string of numbers that looked to be a credit card number. And this was because they were within scope for PCI, and as far as they were concerned, if data was coming in that happened to be a credit card number, they didn't want to be responsible for it, and of course, it's obvious that they didn't want any leaking out. So I'm sitting there at this customer, and they happened to get a fairly aggressive call from a member of staff, a very high member of management. And what he's been doing over the past few months is actually negotiating the purchase of some trucks for their local authority. And so he's been sending some statistics and PDFs and brochures back and forth to various different organizations. And once they implement this solution, that message happens to be blocked, but no notification sent in. So he doesn't know. Everybody just thinks that he's gone quiet. And so they do some investigation into this. And what they actually find is that the PDF that he's been sending, it contains some tire pressures, some weights, some axle lengths, and they happen to, for I guess bad luck reason, happens to actually trigger the script for a Visa MasterCard. So this manager is not very happy. He sees it as interfering with his job role, preventing him from doing his job, and needless to say, the project is canned. So just in kind of summary, I guess, to that, why did it fail? Well, 3 points really. They hadn't tested the solution properly, and I must admit, as I wasn't involved in this project, it is a little bit summarization on my part, but they clearly hadn't tested properly. They hadn't tried enough forms of data. They hadn't got enough people involved from various different departments in the organization, and they had no management sponsorship. This guy who was of a high nature within the organization should have been aware of this project, and he should have been on board with it, and if he was, he would have understood what was actually happening. And finally, there was no data classification taking place, and that's a point that I'll carry on to the next question.
Okay, excellent. Chris, what oversights are people likely to make with the implementation of a DLP solution?
Okay, so as I say, I'm just going to return back to that kind of data classification piece to answer this, and I guess I'm going to try to kind of take it in a slightly different spin here. But one of the most overlooked parts of any DLP solution, at least in my opinion, is data classification. And just to give an idea of what data classification is, there's a great analogy that we can kind of take, one that we're all familiar with in the real world. Now, if we think about the way that a courier or a postman does his job, when he needs to deliver something, he has no idea of the contents. And so in my analogy here, I'm going to place something of very significant importance into a box. Right now we have no idea where that is. The courier doesn't know, nobody knows until it arrives at the destination. So the question is, how does that courier or that postman know how to treat those individual boxes? How does he know which one is sensitive or even fragile and the others are fine? Not that he should be kicking the boxes anyway, but we need to treat it accordingly. So the courier industry and the delivery industry have been doing this for years. And what they actually do is they apply marking to their boxes. We don't need to show you the content, that's secretive, but we can actually indicate to the rest of our solution set what happens to be the parameters for handling this type of information. So the first thing that they do is they apply human readable markings. So we can see here that it's fragile, we must take care in moving it. We can see that it may contain some glassware, not in this case, but this is standardized, I guess. It may not be waterproof, and of course there's a direction here for holding it up in the right orientation. We also have machine readable markings. Of course, in most couriers, postman, delivery networks, it's a barcode reader that moves boxes via many travelators. And so they use these two methods, and we can translate this into IT. We can take this concept that's nicely, well tested, and implement it into IT. And one way that we can do that I can highlight is email. One that I speak to customers a lot about. This is data moving constantly. This is something they're very concerned about. We all heard the statistics of how many billions of emails are going around the planet at any second in the day. And so this is a huge space for data leakage. So in terms of applying classification, what we've just spoke about, to an email system, what we can actually do is we can classify our email upon sending. So in my example here, I'm keeping it very basic, but we've got, say, a green for non-sensitive, a red for sensitive, for example. So we'll concentrate on the green first. So if somebody says that the email contains non-sensitive information, they will send the email, they'll classify it will go to some kind of inspection service, and it will make its way to the recipient. Okay, that's a very normal workflow that we're very used to working with. The opposite to that is if the email contains some kind of sensitive material. And so what happens at this point is we would have a solution injected some kind of metadata and some human readable markings into that email, which will then be picked up by the email inspection service and maybe sent to something appropriate for that data. So it could be blocked, it could be prevented from going to external recipients, it could be stripped, for example, or some of my really kind of impressive customers are using things like email encryption services. So if you say it's a sensitive piece of data, it gets encrypted, it hits the recipient. If it's the intended recipient, of course, they can unencrypt, they can see the visual marking, so they can treat it appropriately again, but they can get that data they need it. If it's the unintended recipient, well, they're not going to be able to decrypt that particular email.
Excellent. Thanks very much, Chris. Are you able to provide some insight as to what the new role of the IT security manager will look like, in your opinion?
Well, again, I think this is a great question because, and hopefully a lot of people on this call can empathize with this, but most of us start our career out becoming some kind of leader in an IT department. And I think that it's changed dramatically, say within the last 10 years. Most people would have joined an IT team doing support maybe, eventually knowing the systems to a point at which they get some kind of leadership, but they always remain techie at heart. And when they become a manager, they actually start to be entered into this realm that's a little bit more scary for them. So, and I think that in terms of how the IT manager role has changed is really indicative by this graph that I've asked to be put on the screen, which again has come from the ITO website. And this is, in 2014, the breakdown of types of incidents, security incidents that have taken place. And you can just see from this wide variance of things, the IT manager's role is not just about directing resources to answering IT tickets. We've got things here like, we've got insecure web pages. We've got things like paperwork. When did an IT manager have to think about disposal of paperwork? We've got things like, what else have we got on here? Faxes, for example. We've got data sent to incorrect recipients. These are all things that are keeping the IT manager awake at night. So what I've actually found within the last 10 years, particularly in very large organizations, is that the IT manager and the data security manager have become two different roles. and actually tend to have their own teams. And this is particularly common, I tend to find, in public sector organizations at the moment. So what they'll actually do is they will have their IT teams provided by a managed service. They'll pay a subscription cost, I guess, per year, but they'll keep their security team in-house, which is a really interesting way of doing it. So generally, the security team will be looking after compliance. So they'll be, I guess, ticking the boxes, making sure everything is happening for them once it comes around to audit time. They'll be saying yes or no to change control. They'll be taking vulnerability assessments and, I guess, asking the IT team why certain things have failed. And, of course, they'll be creating policy. And so what I've highlighted here is that the security team tends to not really be that technical. These guys are just really laying down the law. They're almost like mini legislators within their own organizations. The IT department, however, tends to stay very much the same. So all we've really done is take out from the IT team and the IT manager the things that are a little bit different to the role that they, I guess, originally signed up for. So we've kind of got this watcher of the watcher situation here. So that's kind of how I see the changes in the IT manager role over the past few years.
Excellent. Thank you so much, both Dan and Chris, for providing some really valuable insight into the EU data protection reform and what organisations can do to prepare. Now I'm going to open up the door to some questions and answers. If you have any questions, please submit them via the Q&A panel shown on the right side of your screen and indicate who the question is directed to. So I'll just wait 30 seconds for those to roll in and then we'll just get started. Okay, they're starting to roll in. Dan, this question is for you. In your opinion, how prepared are UK organisations for the changes on the horizon?
Not very prepared at all, and that's not just small and medium-sized businesses, but also large organisations. I think a lot of the problem is that, as I've hopefully got across, that the precise content of the draft regulation is still up in the air in many respects. And it's very difficult for organisations to start thinking meaningfully about a lot of the future obligations when they're not really entirely clear what they are. But having said that, as I've said, there are some themes out there which we know are going to appear, and the appointment of a data protection officer is a good example that any sizable organisation is definitely going to need to do. And I think it's fair to say that, Chris has hit the nail on the head, the head in the sand, using different contexts, but I think it's applicable in terms of looking ahead to future compliance with the regulation. There's an awful lot of that going on, and it's not helped by the fact that we've had 3 years now of the draft regulation being in circulation, and it's still not that close to being agreed. So I think people start to get a bit jaded looking at the regulation, thinking, well, I'm not going to do anything until I'm absolutely certain it really is going to come into force. But it is going to come into force, and it will be within the next 2-3 years. So there's plenty that people can be thinking about now.
Yeah, okay, fantastic. Thank you, Dan. This one is also directed to you. If the regulation will have direct effect, why is there a lead time allowed?
Well, that's a very good question. I think, as with all significant legislation, there needs to be an opportunity for organisations and individuals to get their house in order and to alter their operations, to give them an opportunity to ensure that they are compliant on the date that the lead time expires. So there's nothing new there. It was the same with the Data Protection Act in 1998. It didn't actually come into force until 1999. In fact, some of it didn't come into force until 2001. So I think it makes sense to ensure that everybody can alter their operations and their procedures and policies and so on to make sure that everybody is compliant and that the law operates properly.
Thank you, Dan. Chris, this one is for you. What kinds of data are IT administrators going to have to make provisions for based on these changes?
So that's, yeah, absolutely. So I must admit, I'm not as au fait with, I guess, the changes as Dan maybe will be, but certainly from my interpretation, some of the things that I've been reading up on about these changes to the legislation there's some really interesting pieces of data or information, I guess, however you want to interpret it, which a lot of IT managers or security officers may not think are covered. So, for example, I saw another webinar very recently where they mentioned the use of pictures. So, you know, a couple of companies I've been to, they have photographs of staff events. They may have photographs that they use on things like ID badges, for example, and these don't tend to be stored in the same way as what they consider sensitive data to be. I guess you can see this guy walking about the building. How sensitive is that? But pictures are taken into account, particularly if these pictures happen to be of people external to the organization that maybe haven't given consent to the fact that those pictures exist on the network. So that's definitely a piece that was quite surprising to myself to hear, and has certainly stuck with me since hearing that.
Thank you, Chris. There's also a comment, I believe this would be directed at you, Chris. Security breach is necessarily a data breach.
I'll definitely give that a go. So yeah, I completely agree with you. Just a very basic case, maybe somebody losing keys or a key card to a building, again, would be a security incident. Very recently, I was looking at, and you can go and Google this yourself, but if you have a look at NHS Hospitals Cumbria, they actually publish all of their security incidents online, which is very progressive of them. And, you know, a lot of stuff listed in there that you wouldn't necessarily think of as being data breaches, or you wouldn't always kind of assume were data breaches, but of course are that case. So, for example, I think I read somewhere they left a wheelchair out in a public area, and the patient details on a clipboard happened to be clipped on the back, so, and that clipboard happened to go missing. So absolutely, completely agree with you. It's not just about the traditional, somebody hacks into a network and steals some sensitive files. It takes various different forms.
Excellent. Thanks very much. Thanks very much, Chris. Now, Dan, does this presentation take into account some of the recent comments from the December version of the regulation?
From the what? Sorry, I just missed the end of that. Take into account the
recent comments from the December version of the regulation.
Yeah, absolutely. Because as I said, you've got the three different European bodies who are all constantly evaluating and commenting upon the regulation, and they are feeding into various different drafts, the latest of which was the December version. So absolutely. So where I have mentioned in the talk that the precise nature of a particular provision, for example, the maximum fine, where I've mentioned those particular things and said that they are still up in the air, that is the position as at today.
Thank you very much, Dan. We're running out of time. I can see that there are some unanswered questions, but please rest assured that they will be responded to separately within the next 48 hours. Thank you very much, Dan and Chris. So to all webinar attendees today, you'll receive a DLP implementation 10-step action plan white paper. So you'll receive an email about this in the next couple of days to help you on your journey to compliance. We also have an exclusive offer for all webinar attendees today. Finegate are running a data loss prevention technical workshop at our offices in early April, where you can learn more about how to complete a successful DLP rollout across your organisation using best-of-breed security solutions. So please look out for these details in an email that will be sent to you in the next couple of days. Once again, thank you to our guest speakers, and thank you everyone for attending. I hope you enjoyed today's webinar on the EU data protection reform and what you can do to prepare. Enjoy the rest of your day.